is 11:16. I'm going to go ahead and call the Sioux Tribe Enterprise Authority meeting to order. We'll start with roll call, please.
Lana Cosley Smith.
Here.
Rob McGrory.
Here.
Michael McCurchie.
Here.
Larry Barview. Sean Borowitz.
Here.
Kimberly Lee.
Here.
Bridget Sorensen.
Here.
Aaron Paymont.
Here.
Isaac McKechnie.
Here.
Kimberly Hampton.
Here.
Kimberly Gravel. Tyler LaPlante. Austin Lowe's.
Here. Okay, guys, we have a quorum on today's meeting. We have two items. They're titled Minutes from 3/24/26 and a resolution titled Adoption of Enterprise Authority Logo. With that, I'd like to entertain a motion to accept the agenda. Motion from Isaac and support from Lana. Any discussion on the proposed agenda? Hearing none, those in support signify by saying aye. Aye. Those opposed? Those abstaining? Motion carries. We have a agenda. So the first item is minutes from 3/24/26. I'd like to entertain a motion to accept them. Motion from Isaac, seconded from Lana. Any discussion on the minutes? Hearing none, those in support signify by saying aye. Aye. Those opposed? Those abstaining? Motion carries. That brings us to the one and only resolution that we have for today, which is titled Adoption of Enterprise Authority Logo.
Now therefore be resolved that the Chief Executive Officer of the Sioux Tribe Enterprise Operations is authorized to implement and administer the approved corporate brand identity, including the rollout and application of the EDC logo across enterprise operations in a manner consistent with the governance oversight of the Sioux Tribe Enterprise Authority. Be it further resolved that the Chief Executive Officer of Sioux Tribe Enterprise Operations is authorized to develop and implement enterprise-level branding standards, sub-brand structures, and related visual identity elements necessary to support a unified enterprise brand architecture with periodic communication to the authority regarding significant branding initiatives. Be it further resolved that the Chief Executive Officer is authorized to update all policies, internal enterprise documents to reflect the new name for the EDC. Be it further resolved that the Business Board of the Sioux Tribe Enterprise Authority hereby approves and adopts the attached EDC logo as the official corporate-level brand identity for the Enterprise Development Corporation. Be it finally resolved that the approved EDC logo and associated brand identity shall be recognized as an asset of the Sioux Tribe Enterprise Authority and incorporated into the authority's intellectual property catalog.
Motion from Isaac,
Support.
support from Kim. Dan, could you explain this resolution, our efforts thus far to get a new logo, all that kind of stuff?
Yes, this is just part of, this is one of many initiatives. We've been addressing structural deficiencies to optimize structure for commercial business performance, working on a strategic plan. So we have structure, strategy. This would be, now we need the element of identity. This would be to slightly change the name from Economic Development Corporation to Enterprise Development Corporation to give it this brand identity aligns more with a commercial operation. And aligning identity at the Enterprise Development Corporation, which is now the corporate level enterprise, providing strategy and oversight over the other enterprises, will then, once this transference happens to the new logo and brand, we will begin working through each individual enterprises. They'll each keep their name, but then this will give us a sub-brand to give identity to the entire enterprise portfolio.
Okay, I appreciate it. And this is obviously to update the logo for EDC, not the overall tribe as a whole. So this is point out. Any discussion from the board? Okay, hearing none, those in support signify by saying aye. Aye. Those opposed? Those abstaining? Motion carries and that logo is adopted. That concludes all the items that we have for today's EDC Authority meeting. So without objection, meeting adjourned.
Thank you.
No objection, meeting adjourned. Thank you.
I think that's what this long one over here is.
Joe, you're not streaming
Recording
anymore?
stopped.
That's all they had.
Check, check, check. Mic.
begin. The item that we're currently on is proposed Chapter 15 FOIA Code Amendment. This is something that we wanted to put on. Ryan, our general counsel, he's going to guide us through it. From now until the meeting starts, unless we go and close, it's open and it's being televised to the membership. So Ryan, why don't you go ahead and get started?
Testing. Good? Clear? Loud? All right. Yeah, this was meant to be workshopped several workshops ago. It was brought up initially in our conversations with the constitutional amendment drafts we're working on. Director McGrory asked to workshop FOIA in part because our FOIA code right now only applies to governmental entities. So one of the big changes here that you will see, and right on the first page, you'll notice we added a new section, 15.116. We're calling it right now Sunset for disclosure of proprietary business information. This was driven by a desire from the board to open up a pathway for like Kuwaitan, Gaming Authority, and Enterprise Authority documentation to be FOIAble at some point in the future. And in the draft constitutional amendments, it mandates that, and our current laws are not structured that way, nor is our current constitution. So this is our attempt, our first pass at getting this law updated, proposed updates to make it so our economic arms do have some ability for some of their documents to be FOIAble.
Aaron?
So one thing that, a couple things, concerns with the way it's structured right now, even just with the governmental, is I can remember when it was proposed, it was like this big to-do, right? Like we're going to become transparent, we're going to communicate, blah, 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 blah. But the way that it's structured now leaves it almost entirely a discretionary decision. And I think that's problematic. I think if we were to articulate like a procedure of what is confidential, what's not confidential, I also think it's horribly unfair that we put it on the board administrative assistant, because then she's left having to interpret, and I'm guessing she checks with legal, then it leaves it up to legal to decide, and then it's a discretionary decision rather than a real clear sort of, is this open information or not open information? So I think whatever we do on the enterprise side, we need to make clear if we have a separate FOIA on the enterprise side, because I do think there's information on that side that should be considered confidential, proprietary, and business, but I also don't think it should be just discretionary, arbitrary, capricious. We decide from meeting to meeting, or leave it up to one person to interpret, or even the legal department interpreting it. I think that good policy is spelling out and predictable, not arbitrary and capricious, or changing from time to time. I think I wouldn't have a problem with it being administered the way that it is with the board administrative assistant if we had those guidelines. But I still think it's an unfair position to put that person in. I think the position that that Letitia has might be more, because it's more compliance. It used to be really compliance when we had our gaming control license, but it's still tax code. So I think that would probably make more sense. But whatever we do, I think as long as we articulate out and define out so that it's not arbitrary and capricious or discretionary decision. But I do think on the enterprise side, it needs to be tighter. In the past, is this live right now? Am I speaking live? So in the past, I'm just going to call it like it is. In the past, the way that that those decisions were made was the board office would, so I'm saying in the past, I'm not saying currently, the board office would not bring the minutes for decisions that were made by the board of directors for any kind of enterprise investment or development until after a certain time period, like 6 months. So we were like kind of informally putting a sunset on it. But the problem with that is the citizens of the tribe have a right of referendum. And when, and normally, like the details of a business plan or whatever go into closed session. They're discussed in closed session. We don't make any votes in closed session, we come back into open, but we reference what was discussed in closed session, or we reference an attachment. And then when we vote on it, we don't make the minutes, we don't bring the minutes for approval until after the 30 days. So, you know, whoever, I don't know that we ever designed it that way, but it does circumvent the right of referendum, because people wouldn't even find out the detail of the deal that we made. We didn't make the deal behind closed doors, but people couldn't referendum any decisions because they weren't aware of them until after the expiration of the 30 days. So, so I still think there are enterprise and business decisions that should be exempt from FOIA, but I think that if we do that, we need to define what those are. There should be some kind of a guideline that defines that, so we're not making arbitrary and capricious decisions from decision to decision. That's it.
All right, we can keep going, Ryan.
So starting at the top here, hopefully you have it in front of you because I can't, not screen sharing, but purpose and authority. We made a small change here. I'm not even on the Zoom. Sorry.
Screen share it?
Do you want me to get onto the Zoom and try and screen share?
I can do it for you.
Okay.
I just gotta pull it up.
My Wi-Fi is kind of spotty. Right now it says the public policy of the tribe that all members are entitled to full and complete information regarding the affairs of government and the official acts of those who represent them as tribal officials and tribal employees. Consistent with this chapter, we've struck that language and just said regarding the affairs of the tribal government. And further down in our definitions, it defines like what a government action, official government acts are. This was in part to be more consistent with the intent of this Freedom of Information Ordinance and forward thinking if we adopt our three-branch government in substantially similar details as we currently have it drafted, this would be in line with the future Constitution. So it doesn't change the effect of what's happening. It's just some wordsmithing to be in line with current operation and future Constitution amendments. Same thing in 15.102. These, number 3, these exist to present uniform guidelines governing the disclosure of public records of the tribal government and the redress of wrongly withheld information while recognizing the need to protect certain information that if disclosed may be harmful to the tribe or to individual tribal members. Because this really, like other freedom of information laws in our country, is designed to target our governmental records. And this was always the case with this. We wanted it more clear. So those are the 2 changes there. Going down to definitions, 15.103, number 5, tribal body now explicitly does not include the Gaming Authority, Enterprise Authority, Gaming Commission, Sioux Tribe Incorporated, or any other authority created to perform functions outside of the tribal government. Before this section read that this excluded the tribal court and no other authority, although as we get down further and what we talked about previously and what this board reaffirmed is that it was always intended not to cover the Gaming Authority and the Enterprise Authority. And so we made that more clear in this proposed definition. Number 6, we've added a definition for reasonable request. Our Constitution refers to a reasonable request, and later on in the code, it talks about reasonable requests. And to Director Payman's point, this definition may not be quite there yet, but it's an attempt at least to define what that reasonable request is, so it's not so discretionary on the agency or the department.
Aaron?
So on this one, the way it's been handled in the past, and we've been actually pretty good about honoring requests, and if it was a huge request, we would assign them the cost. They'd have to pay for the cost of printing. But this one says without significant effort or expense. So this one kind of suggests that if there is a significant effort or expense, you don't get it. So how can it be rephrased so that if there is additional expense, if they pay, if it's reasonable and it's not a huge expense or effort, you know, give it to them, like 1 page or whatever. But if it's 100 pages or whatever, they should pay for that.
Yeah, we have, and this was one area, and I talked with the court about this previously, and they flagged this as well. So I didn't have a chance yet to change this one based on that input, but I do agree that we don't want to create a loophole, so to speak, where a department is like, well, this is just too much documentation, so I'm not gonna adhere to this. I'm not gonna follow it. I think if you define this as reasonable request means a written request for information, delete that significant effort or expense, so it reads that is rational, appropriate, ordinary, and one that may be fulfilled by the tribe in the ordinary and usual course of routine record keeping. Then you don't run into that same potential loophole. Because if we're maintaining good records, even if that record is 1,000 pages, our normal course of business, we should be able, as a government, to pull that record. Because it should be, if we're maintaining good records, which I know doesn't always happen in a government, but.
One other thing we should protect against is, and again, I'm all for open access, but if their request, I guess it would just not be reasonable then. If their request is, I want copies of, you know, blank, whatever, going back 10 years, that costs the tribe significantly for staff to spend time and effort to go get that. So either that would not be a reasonable request, or if they're willing to pay for the time and effort that it would take to go and do all that research, that could be a reasonable request if they're paying for it. But
Yeah, and the tribe for a number of years had gotten away from charging for FOIA, but we've since in the past probably year, maybe a little less, because we've had some really big requests that were a lot of staff time. We have been using our current authority in the code to charge reasonable costs to fulfill them, because sometimes we get very time-intensive things that should be fulfilled, but it takes a lot of time and resources.
But we're probably not charging staff time, are we? Oh, we have?
Right now it is, and I would change to that further down too.
Yeah, and I support that. I think
is-
we just have to be clear.
Yeah, it is allowed right now in the code, and we have been charging for the staff time needed to pull. Is everyone okay if I delete that significant effort or expense? I recommend deleting. I think Director Payment's point, and it's the same thing the court raised, and I had spoken with them about. I think that it potentially limits, or provides the departments with a loophole to limit requests, which is not my intent in drafting this.
Is everyone okay with that?
Okay.
Okay, I don't see any objections, Ryan.
We're adding a definition for proprietary information next. Right now the definition reads, proprietary information means information related to the tribe's activities that may include, but is not limited to, information or data that would divulge trade secrets, research and development of existing or future projects, blueprints, contracts, vendor lists, property clearly marked as confidential or as proprietary information or other such documentation that, if released, may place the tribe at a competitive disadvantage. This definition is a combination of multiple definitions from different other like state FOIA codes, some legal dictionary definitions, and so this tries to capture what other jurisdictions do in their definition.
I have a question.
Yeah.
Or maybe
Aaron.
a comment. So it depends on when they ask for the information. Vendor information for some of our bidding is not, we can't keep it confidential.
Right.
Federal contracts, we're required to post it. Who's selected is all public information. So we just, if this is a vendor list of somebody who's been chosen a while ago, and we have a vendor list, that's different. But just making sure that whatever we put here doesn't limit access to what the federal law requires us to provide, and that is during procurement.
Okay, keep going, Ryan.
Yeah, and we do have further down, and like, I think it might be in the exemption section, things that are, already have to be disclosed by other law, like a federal law. We don't have the ability under our code or this version to withhold it. Things that we already deem public, like if we have a vendor list that maybe I don't know, we use it for the golf scramble or something, right? That we already, maybe as a tribe, consider that to be more or less public. It wouldn't affect stuff that we have already deemed to be public or stuff that would be public under a grant or a federal law. That all would still be able to be released, even under this definition. That's why we put it as a may, too, because there will be times where some of these things, like the contracts maybe, or the vendor lists, will need to be or can be released if they hit the sunset clause or if another law controls, like a federal law. So we didn't want it to be a shall, because for that very reason. Yeah. All right, scrolling down to 15104, access to public records. We've added to this section, I'll read it all here. So a tribal member must submit a written reasonable request to the public records officer that describes the public record sufficiently. That's the current language. We've added, and with specificity, to enable the public records officer and the tribal body to identify the public record. It's the responsibility of the tribal member. It's the responsibility of the tribal member to clearly articulate the records they are requesting, to determine if the request is a reasonable request, per our definition. If the public records officer cannot sufficiently determine what the request is because of the tribal member's failure to clearly articulate the requested public record, the request may be denied. Upon denial, the tribal member is free to make a new, more specific request. Sometimes we get requests that are so vague they're hard to determine what exactly the tribal member might be looking for. Yeah, any and all type of language. Maybe they don't exactly know what they're looking for, and we've had disputes with the court that the public records officer should try to help the tribal member figure out what they're looking for. I do not believe that is the proper use of the public record officer's time or position. The tribal member, fortunately or unfortunately, needs to be able to determine what they're looking for from the government, and then we'll find it. And that's what this addition is helping to clean up.
So
Go ahead, Aaron.
I support what you just said, because if you want to invoke our laws to ensure that we're following our laws, it's not the tribe's responsibility to coach somebody on what the citations would be or what the laws would be. And so I think that it's up to the person to understand what they're looking for and to do the homework to make that request. I would say that it puts the officer, if that's the title, that public officer, in a tough position, because then they're coaching them on what to ask for, and that's not their role. Their role needs to be a neutral arbiter of what access you have access to, and not somebody who's coaching you or writing it up for you or drafting it for you or doing the legal research for you or any of that. It should be up to the person to know what it is that they're looking for.
Yeah. So. Exactly. We've had requests where almost feels like the requester wants to use our staff as like a legal researcher, and that's not the intent of a FOIA ordinance. So that's, yeah, exactly right. Let's scroll down to the next big change. Oh, we had here in 1508, number 4. This is the extension language. If unusual circumstances exist, extends not more than 15 business days, the period during which the public records officer shall respond to the request. The public records officer shall not issue more than one notice for extension unless the volume of the requested document exceeds 1,000 pages. We were trying to workshop some sideboards of requests might be unreasonable. This was before we added the reasonableness definition. I had the court look at this, and they thought that was arbitrary, and I agree. So I've stricken it out, but I want to just make note. We had that change in there with the workshopping with the court. We agree that that's arbitrary, and we think the reasonableness definition covers what we were trying to cover in this section. So no matter how big the volume might be, that's not a basis to extend more than that one issue of extension. 1509, a written notice of denial of request. We've cleaned up some of the language here in number 1. The language in our code currently reads, if the denied material is claimed to be exempt from disclosure under the exemption list, then we can deny it. I think a better phrasing of this is we have in our code what is exempt and what isn't, so we're not claiming it to be exempt, it's just exempt per code. So now it reads, if the denied material is exempt from disclosure under that list, then it gets denied. That's how, I think that's a better phrasing for the code. I've also added number 3 here. If the requested material is already available to the public, a statement informing the tribal member of where the material / information can be found can be sent with not denial letter, but whatever letter they get. If it's already public, it's already on our website, it's already on another agency's website. We've had requests for information that is maybe they want to know how much iGaming revenue each tribe gets or what our tribe gets. That's all on MGCB's website. We're not gonna go do the research for you, and we'll just tell you where to find it. Or they're looking for a resolution, we'll tell you, go to the download section under the board of directors, all the resolutions are there, open the 2024 folder, there it is. I'm trying to limit in the new proposed code how much unnecessary staff time might need to go for a request that's already somewhere on our website or on another agency's website, so we can focus on fulfilling the request of public records that aren't already posted somewhere. Number 4, we're adding, if the request is not a reasonable request as required by the tribe's constitution, bylaws Article 3, Section 1, and as defined in this code, a statement denying the request as unreasonable will be sent to the tribal member.
Aaron?
Do we keep a compilation, like in a bulletin or something that over time we can take a look at to see what is reasonable, what's not reasonable?
We're only required to keep them for a year.
Yeah, no, we don't do that now, but we've talked about something similar, and we think at some point the tribe should have like an FAQ, like a frequently requested FOIA, because we get a lot of duplicate FOIAs, and they're easy to do because we've already gotten them, so we just pull what we did last time. But we've talked about something similar, Aaron, where we'd have on our website, like, here's a frequently asked questions of FOIA requests, and then just maybe have some information available. I think we keep the records a year.
We're required to. I haven't deleted anything yet, though.
So we don't have like an internal compilation that stretches back too far, because I think some of the records cycle out, but it's something we can consider.
So one thing we might want to think about doing is we have to up our game as a government when we create a separation of powers, because before that, you know, we're a unitary form of government, arbitrary and capricious approach to governance, is the courts are going to have judicial precedence. Under Administrative Procedures Act, we would have bulletins that would go back to the beginning of time that say a request came in, it was denied, it's posted here, it's got a number, and then that way, going forward, we don't make a denial in one situation and then we give an approval in another situation because we didn't have that record someplace. So I think under the APA, it's a bulletin. It's called a bulletin.
Yeah.
So those types of decisions are researchable, they're rational, they're objective, and they're memorialized. So
Yeah, I think it's a good idea. We've talked about it in slightly different contexts, but I think that's something we can do now, and definitely in a separated government, it's even more important to do that. I agree.
And when the officer gets the request, it may be the same officer, you know, because we had Joanne for like how many years? 35 years, 30 years. It may be somebody different, but I know that if I was that person having to make that decision, I'd like to go look to what we've done in the past to see, have we granted this before? Am I going to be inconsistent with saying no because it's this person, you know, sort of thing? And a bulletin and a record of what we've done in the past will guide us going forward.
Yeah, and we do have that process sort of set up with, like, the Lana will get the request and she'll check with the department and then she'll check with legal and we'll all kind of work together to help fulfill it. And we have at least the knowledge from the 3 years that I've been here of what, so we're consistent in that way, but it doesn't always stretch backwards beyond that, right? We don't always have the records maybe of the last public records officer, which is what you're talking about, and I think we need to be better about that.
Plus, any procedures that we have should transcend who's in those roles. It should be able
Yeah.
to withstand the test of time.
Yeah,
Can
exactly.
we just clarify really quick that as a public records officer, it's not my role to deny or approve requests, I just facilitate them. I deny and approve if it comes to records in the board of directors office and purview, but if something comes in for the casino, I don't say, sorry, you can't have that. I send it to Alan and legal. I'm not saying yes or no. I'm facilitating getting the response, and I provide the response to the member asking for it, no matter
Yeah,
what
yeah.
it is.
Well, the code doesn't quite read that way, maybe, but that's how we've been
So Lana
handling
reaches
them.
that
So
decision.
Kuwaitan will get a request and they'll say, well, we're exempt, so you can't fulfill this.
Yes.
And then
That makes sense, but I
right.
think that's the way the code should read.
Yeah.
Yes.
Because then the public officer is just the recipient of it and forwards it on. But at some point, you got to identify who's making the decision too. So that should be,
it does right now, Aaron, like you said earlier, it kind of, when there's a question in the department or entity, if it's not clear, like Kuwaitan's like, well, we're exempt, so we're not going to follow it. If it's maybe, I don't know, something in, like an accounting, something financial, and the accounting pulls it together, they might not be confident whether it should be exempt or not under our code, and then they tap in legal, and then we ultimately will give them advice on if we think it's exempt or not.
so if it's going to become regulatory, we do need to think about making it clear and not discretionary to the manager, because I'll just give you one example. We've had problems in the past where safety has issued certain directives for safety issues in the casino,
Yeah.
and the casino barred all the safety officers from coming into the casinos. So, so we don't ever want a situation where, you know, or legal gives the advice, but they're like, well, you're not regulatory. You can't do anything about it.
Right.
So we had, I don't know how much, thousands of dollars in lawsuits of people who fell down the steps at the Dreamcatcher because they would not follow safety's recommendations. So
Right.
I think it was like maybe 50 or 60,000.
Kim?
And I was gonna say the same thing about the, I forgot that part. Anyways, keeping the log, because you'll be surprised at how many times the same person will request the same information, maybe a year or two later, because they lost the information they received. So I don't know if there's something, you know, like, we've already given this to you, we're not gonna do it again.
Not a reasonable request.
Right, right. And you were saying something, I was gonna add to it, but if I think of it, I'll raise my hand again.
Or if we keep really good records and we know Ryan Mills on this date 2 years ago asked for this, and he's asking for it again because he forgot or he lost it. Maybe that's easy to, maybe it's easy to pull because we just had, we forward the email, hey Ryan, you already asked this 2 years ago, here it is again, right? I don't know. It can cut both ways, I guess. I do. All right. We added number 5. This goes to the reasonableness definition and some of the changes up above. We've added here that it can be denied if the request did not clearly articulate the public record sufficiently and with specificity to enable the public records officer and the tribal body to identify the public record. And that goes hand in hand with what we talked about earlier, where if that happens, the tribal member can just resubmit and try to be more specific so we can identify what they're actually looking for. But doesn't mandate that our staff try to, you know, take a shot in the dark and maybe you meant this. Just redo your request and be specific, please. Moving down to 15.112, production of public records. We've added at the end of this, any request for any contract, financial document, or historical rolls that are not exempt from disclosure may be examined only in person and may not be copied. Any public record produced under this chapter may be subject to redactions by the tribe. Part of this is attempting to, so if we have a big request to fill, or maybe they want to look at a bunch of contracts, maybe the sunset clause has hit and the contracts are foiable, but we don't want them, we still don't want them widely spread on Facebook, et cetera. You can look, you can still view them, we're just not gonna maybe copy them, come in, look at them, same with financial documents. Same thing if you want to maybe look at the tribal rolls, maybe we don't want to just publish all of our rolls, on the internet, we're allowed to look at them, so you can come into our office, set the time and date, and look at them that way. That's what this addition is trying to cover. In addition, there still may be times, maybe the contract has a non-disclosure agreement or something in it, where even though some of that contract should be allowed to be viewed by the public, there may be things we still need to redact for reasons that we've agreed to with that vendor or contractor, and we want that ability in those cases to still redact certain things, or maybe there's identifying information that if we don't redact it, we'd be in violation of one of the other exemptions where, because it's not redacted, you can personally identify the tribal member or person, and so we want that ability to be able to redact those sensitive things if need be. Make sense? Let me find the next change. Okay, we're into our 15.113 exemptions from disclosure. These are pretty solid. When I was workshopping this internally with our department and with the court, we didn't have a lot of changes here, but the one thing we all agreed on that we need to be better at defining, which is why we added a definition, was the proprietary business information. So we've added the definition up top that we talked about earlier, and we've also added in W here that proprietary business information that, if disclosed, may place the tribe or a tribal business or economic enterprise at a competitive disadvantage, involves a currently active contract, involves a contract that has confidentiality clause or non-disclosure clause, or involves documents discussed in closed session under Tribal Code Chapter 96.105. Those would also be exempt from disclosure. Just to try to add a little more specificity to the proprietary business language. It's probably the biggest thing when we're a separated government, that if we have too vague of a definition, we're going to be fighting over that in court, even more than we might already in our tribal court in a separated government. This is to allow at least some guidance for the court, so they're not just trying to take a shot in the dark on defining it themselves, so they have some guidance from the legislature on what's proprietary. Any questions there? All right.
Go ahead, Aaron.
It's kind of a concern. I don't know how to deal with it, though, is what if, so we have no shortage of tribal members who would throw the tribe under the bus in a contractual dispute, who would pose as the person requesting the information to get to contract information that could compromise the tribe's risk and create a liability. Only tribal members, this governs tribal members' access. So do we have any language in the code that would specify that it's for the use of the tribal members only? I mean, I don't know how you enforce that sort of thing, but we do have people who were leaking stuff directly to a developer, that we all kind of know what was happening. So if we don't have something, can we put something in here that specifies that the person requesting it has access, but cannot use it in any way that's not a tribal interest, something like that?
Yeah, potentially. So you want to add something that covers it and then figure out what the teeth are, what the violation, if you violate it, what is our recourse as a tribe? I'll have to put some thought into that, Aaron. I hadn't thought of that in that way. What we did think about is in those scenarios where we have concerns of that, or we have a very sensitive contract that we know that FOIA is going to allow this, at least when it sunsets, to be discoverable, but it still could be damaging to the tribe. the entity that we contract with and or the tribe, they may, to protect themselves better, they may ask for non-disclosure clause very tight into the contract. We do that a lot on the Kuwaitan end, not so much on the government end. But if we're opening this up for certain Kuwaitan or enterprise documents to be able to be FOIA'd, you're going to see just necessarily more entities wanting to protect themselves by having that strong contract language where, so then only certain portions of the contract would ever be public. Did I lose it? Is it too loud? Lon told me to be loud, so. So we can cover it that way, the way I just talked about, but I think we could also put our heads together and try to cover it in code as well.
So just, I guess one example to take it away from like the business side is, you know, we have a position as a tribe where we're opposed to Line 5, right? We know there's tribal members that work for a subsidiary of Line 5 that could just request it as a Sioux Tribe member to get, you know, detailed information about what are you planning in terms, we haven't done any kind of protest in, I don't know, 7 years or something, but you're going to do something, you know. That would not be to our advantage for, you know, one of our turncoats to be running right to, you know, our opposition to tell them everything we're doing through a FOIA request.
Yeah, I made note of it. We'll clean this up. A lot of this stuff it looks like we're mostly in agreement on, and next time it's in front of you, we'll have some other language that we can talk about for the things I'm flagging today. Going down to 15114, fees. Public Records Officer may charge a fee that shall not exceed the tribe's actual cost of reproduction of materials. Actual costs shall include printing costs and the hourly wage of, I've added, lowest paid staff member that could produce the records. Public Records Officer shall be able to request a retainer prior to starting the production of the records request. So right now we can charge printing costs and staff time, and we can't ask for a bond or a retainer. And looking at other Freedom of Information Acts and looking at different court decisions across the country and talking with our own tribal court, we believe that we should stay, am I still too close to this? We should still be able to charge those costs, but it should be at like an attorney rate. It should be at the lowest rate of the staff member who could feasibly produce that record. So we're being reasonable in what we charge our tribal members.
I have a suggestion. I won't name any names here, but we had an accountant once that was really good at cost estimating. Because, you know, at the board table, we bark out commands and we want to turn around and we want all this research. And this person used to come back to us and say, okay, this is what it's going to cost to do that. And then would bring that to us, and then we'd be like, I don't think we need all of that. But, you know, if you're not the person paying it out of your own pocket, you know, I guess it doesn't matter how much it costs. But when that accountant, you guys know who I'm talking about, when that accountant brought it forward and said, okay, I'm going to do cost estimates whenever you request something, it kind of sobered us up. And we're like, okay, well, we don't need all of that. I think if we did a cost estimate to the person who's requesting it and give them a copy of it, I don't think it needs to be in the code, but give them a copy of it and say, do you realize that it's going to take staff time, that, you know, the lowest paid person, it's going to take all this printing cost, blah, blah, blah. You're looking at like $200. So $200 expenses, is this your request? And let them say yes, because otherwise we do all the work, and then when they come and we offer it to them, but they got to pay for it at the time they get it, they might say, oh, no, I don't really want it.
Yeah, that's a good idea, because it also can help combat potentially, for lack of a better word, like frivolous. We have someone who's requesting a lot of things all the time. If we let them know, hey, we can get this together, here's approximate cost, are you sure you want it? Maybe it's $2,000, and they're like, maybe I only want these 5 things instead of these 15 things. And then they can whittle down their requests, but we're not denying it, we're just letting them know, like, this is what it's going to cost to fulfill it. And that's what a lot of other places do when they get FOIA requests, so I think that's a good procedure to have. Yeah. We've also added in 15114, if a tribal member fails to pay the fee within 30 days, the request for public records shall automatically be withdrawn. This doesn't prohibit them from, once it's withdrawn, they can always request it again later. But we charge a fee and they don't pay it, then of course we don't give them the records.
Default for when the request comes if we don't respond timely?
Yeah, there's one that section. There, I can't remember where section is, but yeah, there's in the timeline to respond, if there is no response. Where is it?
So this would be on the determination of whether or not they have access, if it's
Yes.
reasonable.
So right now we have failure to respond to a request under this code does constitute a final determination of denial. So if we don't respond, right now the way the code reads, that's the same thing as we denied the request.
That's
I didn't change that section, but I
yeah,
can
that's
flag
very
it.
different than typical public access records are a default that you get access.
Yeah.
If we fail to respond of why you don't get access, we make some determination, or we fail to make a determination, the default is you get it.
I'll make a note here, Aaron, and I'll look at some other FOIA code. I didn't even honestly look at this section very closely. That wasn't really, I was trying to focus on the other section. So I'll look at that and see if I have any suggested edits. But yeah, right now, if we don't respond, then it's the same thing as a denial. I'll bring back some language that we can workshop next time. Let's see. Okay, 15115, review of denial. Number 2, this currently gives our tribal court de novo review over a denial. They can appeal to our tribal trial level court to determine whether the court agrees that public record is exempt from disclosure. I didn't make any changes to this, but for discussion, the court, the trial court, our court, flagged whether we should or want to make this appealable to the Court of Appeals. I did some searching on different jurisdictions, and I didn't really find, tribal or otherwise, where tribe did that. But what I did see, and we've talked about this before, is having an administrative hearing code, and that's where a lot of the FOIA appeals get shot to. I think in a separated government especially, maybe we want to resurrect those discussions and see if we want to do an admin hearing code for different things. And that would be a very appropriate place to shoot the appeals of a FOIA denial.
So under the Administrative Procedures Act, that is how it would be handled.
Yeah.
And if it went to the court, the magistrate would make the determination in an interpretation based on, strictly on the law. Although our magistrate's not an attorney, so I don't know about that part, but, a lot of the solutions that we faced over the years, and we have been toying with this administrative law for at least, when I first became chair, we didn't have a legal counsel for a while, and the team that was here then developed one, and then John Burnett dusted it off, and when we reviewed it a couple of times, I don't really think there was any sort of opposition. I think there is some opposition to moving in a non-arbitrary sort of environment where we can't just kind of just say no. So I think that if we could dust that off, I think that is going to be necessary when we separate the powers so that a body of decision-making is under an APA rather than under the courts. So as an intermediary step before the courts. But then you have to exhaust your administrative remedies before you can file anything in court. So.
Yeah, that's correct, and I think it's something we should put some serious discussion into. Again, I know we've talked about it over the decades, but I think it's time to talk about that again as we're gearing up to have our separation of powers voted on, right? So. Number 6, we've added If the court upholds that records are exempt from disclosure, they may award the tribe attorney's fees not to exceed actual expenses. This was added to the kind of counterbalance. So right now, the court can award attorney's fees to the other party, but it wasn't explicit that the tribe, maybe if it's a frivolous lawsuit, wants to try to get attorney's fees. This creates a balance where both parties can request attorney's fees. I'm not like dead set on it. I just think it's a potential tool to further combat frivolous FOIA appeals in a tribal court. That's the reason for that one. Questions? All right, one more section, then I'll stop talking for a bit. This is the new section. We talked about this in context with our proposed changes to our Constitution, but this is what we're calling the sunset for disclosure of proprietary business information. So I'll just read through it here. It's a bit long. Number 1, any contract deemed exempt from disclosure under 15113 1W as proprietary business information shall be deemed no longer proprietary business information upon the expiration of the contract if 2 years has passed unless a longer time period established in any confidentiality clause or non-disclosure clause of the contract and the party the contract is with does not have an active contract with the tribe. 2, contracts are no longer deemed proprietary business information shall still be subject to redaction by the legal department for any information that could be exempt from disclosure under 15113. 3, production of any contract deemed no longer proprietary business information shall be subject to any production requirements established in 15112. And number 4, records of the Gaming Authority, Enterprise Authority, Gaming Commission, Sault Tribe Incorporated, or any other authority created to perform functions outside of the tribal government shall be furnished to the tribal government pursuant to the parameters and timelines found in their respective codes and governing documents. A, the tribal government, upon receipt of such business records, shall consider them tribal government records for the purpose of this section and this code. That was a mouthful. I'll pause.
So should we include any kind of language that expressly protects against release of information that could create risk or liability to the tribe? You got a timed sunset, but my concern is more that creating a liability for the tribe. So that's one. The other one is, and I know people bristle when I say this, and it's like fingernails on the chalkboard, but you know, it's in my head, so I got to say it. I'm trained in this area, so I'm going to say it. Is when we were looking at handing over the EDC work and assets over to the Sioux Tribe Inc., it was actually a crazy time period where the Sioux Tribe Inc. board did not want to enter an agreement that would allow the Sioux Tribe to have access to our own books. And that held us up for quite a bit of time, for several months. And I said, well, I'm not going to sign it, so you'll have to authorize somebody else to sign it because I won't sign an agreement like that. We actually had people advocating that the tribal records of the tribe could be kept confidential from the tribal government for Sioux Tribe Inc. to have access, but we would not have access to the books. So this section here seems to address that, but I just want to make sure this is before you came to work for us, so it might seem impossible that anybody in the rational mind would advocate for something like that, but it was a push and shove. And I just said, well, I'm not going to do it. You're going to have to vote to authorize somebody else to sign it, because I'm not doing it until they agree and relent that we will have access to our records at any point. There are financial records of the tribe. Separating to Sioux Tribe Inc. would not give them that authority. And for anybody listening, Sioux Tribe Inc. doesn't operate that way anymore, but you never know. The structure we create should transcend anybody who's in it currently. So this sounds like it would protect against that, but I want your opinion on that.
Yeah, I think this would protect against a lot of that. We're still workshopping internally how best we want to advise how to cover like illegal disclosure of confidential information and what code that should go and how we should workshop that. And that will maybe not be all in this code, but this code would cite to that. We haven't proposed that yet, brought it to the board. But the other stuff you're talking about, Aaron, that's what this is intended to cover. Exactly. We want to make sure the tribe has the access to those documents of their economic arms, even though they're not governmental functions. They are still owned by the tribe, and so we don't want to create a situation where they're trying to keep us out, or we're somehow just agreeing to not be able to see those records, and that's primary. This is part of that primary function of this section. We'll have to adopt in the different authority codes similar language for when they send us the documents. That's what number 4 covers especially.
So the other concern I had, and I think you have it covered in the legal redactions, is if a former partner, business dealer, or enterprise that we were engaged in is litigating against us, and not like that's never happened, right? But if that was happening, would that section on legal redactions allow for us to protect against, if we're in litigation, some turncoat on the board or membership, getting a contractual relationship with a vendor, not like that's ever happened, and leaking information directly to the vendor to be at the disadvantage of the tribe and creating risk for the tribe? Would the legal redactions be sufficient to protect us legally?
It would definitely be a strong tool in the arsenal. Yeah, there's probably other things I can't think on the spot that we'd want to also do, but definitely having the ability to redact that for FOIA purposes and for litigation purposes, so we can protect that information to not exploit the tribe, so to speak. Yeah, that's exactly why I want a stronger language to be able to redact those things, and we don't have that right now in our code. And that's the proposed changes for now.
Okay, I appreciate that, and obviously we're going to vote at it at an upcoming meeting. Any final questions or comments on this? Okay, go ahead, Mike.
On the one right before that.
Microphone, Mike.
Hold it. I found if you hold it, it turns green. Yeah.
Oh, there you go. All right. You had mentioned that if the court upholds the records are exempt from disclosure, it may reward the tribe attorney fees not to exceed actual expenses. Was there any discussion on limiting that? Because that seems like that could get out of hand, because some of the tribes, what are actual expenses too? Are you talking wages and fringe? Or, that could get pretty costly, so we may want to consider putting a limit on that. I guess, was there any discussion on that? Or are you just, hey, hit them with everything you got, this is what it costs us to do it, so we're passing that on?
Yeah, with the second one, we didn't really discuss a limitation of that way in code. The court would be able to limit it. The tribe could say, here's all what we're claiming our actual costs for having to litigate this, and now you've upheld our decision, but Ryan Mills made us jump through all these hoops and go into court.
Yeah.
And it was ultimately to their disadvantage. We want an award of this much in attorney's fees. And the court will say, yeah, that's reasonable. Or they'll be like, come on, try. That's not reasonable for your efforts in this. It wasn't frivolous.
Okay.
Even though Ryan lost, here's what I'm actually awarding. But it leaves that determination to the court. The parties will be able to request what they want, and the court will determine.
Okay, the court still has the
Yeah.
ability to do that then?
Correct.
Okay, because
The
to
court
me, it
is-
didn't read that way, so I wasn't sure. So as long as the court can make it reasonable, I'm fine with it.
Yep. And that would be a normal power that a court should and would have, yeah.
Okay, thank you.
Aaron?
I just want to add is as strongly as I believe in public processes, that, again, my first graduate degree was this area, and I firmly believe in the right of the people. But if the costs are attributed to the request, those costs should be borne out by the person making the request. Unless, of course, because we can play both sides at the table, right? Because we're politicians, we might say we want transparency, but then when we're going to assign the cost, oh, that's too much of a hardship for the person requesting it, and make an arbitrary decision. But if we aren't going to assign the cost, as the language says, then we need to budget for what that looks like, because otherwise you're taking staff time away from their duties, their other duties, and you're assigning them to do something else. And if it is exorbitant, the tribe should not have to pay for that. The person making the request should have to pay for that. And I would also say, if we look very closely at indirect and the assignment of expenses for indirect or grants and contracts, those are not allowable under those grants and contracts. That's not their normal duties, so those should be separate. So if we want to come up with this is going to sound weird coming out of my mouth, but if we want to come up with this liberal sliding scale for what we charge people for their expenses, we need to budget for that.
Kim?
I heard someone mention fringe, but that's not mentioned in here, and I was looking at the government FOIA, and it says 50% of fringe on top of wages. So is that something, I heard one, it was either you, Mike, or you mentioned fringe, and
Yeah, Mike.
I didn't see it in here. So should that be in there, or are we going to do that?
So the way that we've been currently calculating actual expenses are just straight base salary, not trying to calculate any fringe benefits. We can make that more clear in the code, I don't have a problem with that. But that's how I would envision that so say, like with
Just
attorney
wages,
time,
no fringe.
if we have an outside counsel doing this, we would do this in-house. But say we just have another law firm doing it, they would charge their hourly rate, and that's what the attorney's fees would be based off of. We would do the same thing. We would just say, here's the attorney time that was spent on this. That's how much that we're asking the court to award. We wouldn't include fringe.
Okay.
in it, though.
Isaac?
Typically, they would include fringe, though, I believe.
I'm saying right now, we're not including.
Yeah, you would include it in the hourly, so if it was $100, you're getting paid per hour, and the fringe is $33, so it'd be $133. Yeah.
Yeah, that's a policy decision. Right now, I'm just saying we've just been doing straight salary, not including fringe when we charge a tribal member. We haven't asked for attorney's fees. We don't have that ability right now. But I'm indifferent on that. That's what the board wants to do, if they want us to do. So it's more accurate to have the fringe calculation with the salary, or make it so it's just base salary, so it's a little less the tribal member might have to pay. That's a policy decision.
Okay, anybody else? Going once, going twice? Okay, I appreciate the work that you did on this, Ryan. Again, this is obviously going to be at a future meeting for us to consider, and then we can have an additional conversation about this during agenda review when it gets to us. So I appreciate it. Move on to the next item, which is land claim fund discussion. So who from staff is going to be helping us out from this? I assume you, Holly, right? Okay. Okay, yeah, why don't you guys come on up front and get set up, and then we'll begin.
How's your battery look?
Yeah, it's good. It's good. Holly, are you prepared to present different options to us on how to supplement that fund, or just purely a board-driven discussion?
I think it's fun because we open discussion. Of course, we have quite a bit of information from sides that just to explain how the inner workings of it funnel through the financials,
Okay,
and then we could discuss some different options.
okay. We'll start with you guys then with that. All right, guys, so the item that we're currently on is land claim fund discussion. We have Holly and Bill up front. So before we begin, can you talk about the history of this fund, how we use it to produce the elder checks, you know, the money that was borrowed against it, how we're paying into that, you know, how that contributes to the size of the check that we have right now. And then finally, the basic math problem that determines how large the check is each year for the elders that receive it. And then if you guys have any suggestions on how to supplement that fund, we'd appreciate that as well. I believe this was put on the agenda to be a board-driven discussion, but as much help as you guys can provide would be helpful.
Okay, we can give some background on the fund itself. As most of us are familiar, we received a settlement from the land claims back in 1998. It was $19,682,386. And we added another settlement in there, Nez Pierce. 215,000 was added to the fund over the years. And then the tribe itself transferred in $1 million over the years as well to add to the base of the fund. Since then, between the earnings for interest, $60,687,589. Dividends, those were the guarantee fees and the interest paid by the tribe for loans. Interest on the funds that were invested, $12,551,643. Gains and losses realized, $1,875,309. And then unrealized, $2,250,381, for a grand total of revenues into the fund through the end of 2025, $98,262,308.
Okay, I appreciate that. If you don't mind pausing for a second, Lana has a question or comment?
Sure.
The Nez Perez, the 215 and the 1 million from the settlement, what year was each of those?
Okay, I'll have to go back.
And you can keep going and just tell me afterwards,
I can find
unless
it
you
real
have it
quick.
right there.
Okay, the Nez Pierce was 2012.
Okay.
And the $1 million from the tribe, Lana, was 2010.
Okay, thank you.
Whoops, too far. Okay, we had some bank charges over the years from 1998 through 2025, $527,938. Other various expenses. We had to put up a bond for stock, and so that was $8,000, and some other expenses that was about $2,400. Payments to the elders over that time period, $85,332,868. And I can send out the spreadsheet that I do. I keep up to date over the years. So you're welcome to write it down, but I'll be glad to send that spreadsheet out.
Okay, Aaron.
Holly got to see my little calculations, and it's pretty close. So you see, it's almost identical. So what I did was, because people are asking this, they always ask this question at election time, right? They also ask it in December, January. One of the constant questions is, can't we just get paid in December? But it has to inure the full interest December 31st, et cetera, et cetera. But I have my little spreadsheet that I did on it. And the one thing that I don't think that we say enough is, first of all, I want to give credit to the person who conceived of this plan, and it was George Nolan. And a lot of people don't know that, but I worked for the tribe early in my career, and I was assigned to work with George on this. And George came right out and said, you know, what I want to do is invest the principal and then use the interest to pay the elders, because we're all going to be elders someday. We're all going to benefit someday. And if we do this right, he said the elders will get more money than if we just all paid it out when we first got the money. And what you just shared with us, and it's a crystal clear point that we don't say enough, is that the principal was originally 18.7, and then it became 19.6, because by the time that we got the money, it was almost a year, and we got that much more interest. So it was 19.6 million, and then we invested it. We used as collateral a couple times, which was a difficult vote for me to make that decision. And I want to give credit again to Bill King from Unit 2, Unit 4, this unit, Nobbin Way. And he said, you know, if we collateralize it and we use the interest, we'll guarantee a return rate. And with ups and downs in the market, we can't guarantee a return rate. And so if we had paid all of it out, even if we paid it all out to the elders the first year, that would be at 19.6. But the number you just shared was we have paid out over the years 85 million. So by investing it in this vehicle, which again was George Nolan's plan all along, everybody else takes credit for it, we have paid multiples over that 20, 40, 60, 80, at least 4 or 5 times what originally that value of the land claims fund would be. So I used to do, when I was chair, I used to do a letter when I was allowed, but the board made a big stink. They said it was politicking. We used to do a nice letter that explained all this, the original investment, the principal, the collateralization, the guaranteed return rate, all of that. This is what you're getting as a result of using it. And then the board voted one year to take that authority away from the chair to send that letter with the checks. And I'm like, I don't care. It doesn't have to come from the chair, but we need to communicate to the people. And I don't think that we do that effectively because the tribe's decision back then to treat the elder fund, the land claims fund, the way we do is one of the best decisions we've ever made. We've collateralized it over the years, which has guaranteed a return rate that you otherwise wouldn't have got. And you know, I also did my little calculation over the years, the total amount, if you were an elder and got paid the first year and you're still alive and you got paid again, the total amount since the inception that you would have gotten is roughly over $20,000, almost $22,000 as an elder. That's the amount you would have gotten so far. We always get beat up because Bay Mills has less people than we have in the smallest unit of our tribe. They only have a small number of people. And the other thing that people don't know is the original deal in order to get the land claims fund is the tribe had to agree to a split, a 35-65 split, 35 for the UP, 65 for the lower peninsula tribes, and then we had to agree to a 65-35 split between Sioux Tribe and Bay Mills. So Bay Mills got a really, really good deal out of it because again, they have less people than we have in our smallest unit. So we had a lot more people per member. We got a very small amount. We probably got the least amount per member among all the tribes, but that's how we had to do it to get the legislation. Bart Stupak sponsored the legislation. It would have never happened. We'd still be waiting for the land claims fund. But I just think we have a really good story to tell, and it doesn't have to be the chair's office, although I think the members would like it to come from the chair, but the board at the time didn't agree with that. But somebody needs to be telling that story, and we need to tell it every year, a couple times a year, to let people know so that they can be grateful and appreciate, and you know what the board did for the benefit of our elders when we created this fund. So that's it. Thanks.
Lana?
We have talked about an article in the paper, but a letter or some other type of communication is fine with us. We can put the numbers together like you have and distribute that however vehicle you want to use, so we'd be glad to do that.
Yeah, we've talked about this a couple times, you're right, Bill, and there has been board members that advocated that be communicated out there. I didn't even realize it was $85 million, so that's a good story to tell, and when you send us that spreadsheet, we can share that with the elders when we go there, because it's important. I think that I did, just most recently, asked that we tell our story about the land claims fund. So that's a good idea. And in the past, Lana Stewart wrote up a very good article in the history. Do you remember that, Lana? Yep. And we distributed that to the membership in the tribal paper. I don't know if we still have that. That was a long time ago. But it was a very good draft or a very good article that she wrote. And we took that around. As a matter of fact, I think one of the legal staff went around to the elders meeting, and they were really receptive on that. So I just wanted to say that we've talked about it here, And I also think that when we get that PR manager position in place, that should probably will be one of his first tasks to work with the chairman. I don't have any objection to the chairman telling that story over and over and over again, because it needs to be said. Again, $85 million over the history of that fund, that's a lot, and I didn't even compilate those numbers to that tune, so I can't wait to get that spreadsheet and see it. And it was Mr. Bill King, 2 decades in Unit 2, not Unit 4. So I just wanted to recognize him.
Okay, let's keep going, guys.
Okay, just because I have it, I can give you a little bit more information. This is on the spreadsheet as well. Currently, at the end of 2025, total assets of the fund, as we all just discussed, it started at 19.6. It's currently $39,828,748. So it's more than doubled, a little bit more than doubled in that time period, even given the distributions and whatnot that we previously discussed. So the big asset there, as we all know, is the loans that the fund has made, $22,300,000 to the tribe itself. We've got some other investments, some land, cash, and those types of, they're all on the spreadsheet, so we'll be glad to send that out. I also have the discussion about the payments and how the elder payments have been determined each year over that same time period. And so the number of elders and the distributions up to the 85 million and those types of things, and the amount of the payment. A few years, for some history, we did have some taxable portions of the payments, if you'll recall. Some of you, if there was money put in by transfer or non-earnings money, then those were what we considered taxable, and they went on a special portion of the form, the 1099 form that the elders might have received at that time. And there hasn't been very much in those types of activities, but it is in the spreadsheet, and the combination of the two made up the payment. I think one year, the first year, because we got the payment, I think in February. Let me go back a little. Yes. And we distributed because of the way that it was distributed, there was a taxable portion as well. The first year, we had $900 we distributed, I believe, right away, and that went to 1,926 elders. And so the last year we had, let's get up there.
Aaron and Kathy Factor.
Oh, okay.
Made the motion in a second to increase it 1 year, and 2 years later we did it again. Then, for the benefit of the members who might be listening, we were told by the IRS that we could no longer do that because it was a taxable event. We could do it, but no, we were told we couldn't. They'd have to pay the taxes on it, number one. Number two, you couldn't then do a distribution without a revenue allocation plan. And we don't have that. And so we had to stop. And so the person who came after me got all the blame for it, and I did clarify it wasn't his fault. The board could not give the supplement because by law, federal law, you can't supplement without a revenue allocation plan. That used to be the case. It's no longer the case. The General Welfare Exemption Act does allow you to supplement a dividend to like your elders or any segment of your population without a revenue allocation plan, but you do have to have a General Welfare Exemption code, and it has to be in your code, and it has to be reviewed by the BIA, and they have to sign off on it. So, and I apologize if I know more than some people want me to know.
So that's a pretty good history. So at this point, what kind of recommendations do you guys have to grow the fund? So we previously thrown around the idea of maybe not awarding 100% of the interest, because the way these checks are distributed is you divide the interest by the amount of elders, and that's what you get. So I mean, the principal isn't growing, you know, when it's set up like that. So that's obviously one way that we could increase the size of that. It would be slow, and then people would obviously take a reduced check until that principal grew. But what are some other ideas that you guys may have? Holly, you gotta
It's gotta be green.
hold it.
First time you gotta hold it.
Yep. And then you should have tapped it.
Hold it, Holly. There you go.
There we go. Okay, sorry about that. So, let's see here. When we do projections, we do somewhat conservative projections, and so there may be a little bit of a discrepancy because we look at the total number of eligible elders, and so if all of those people don't claim, there could potentially be money sitting out in our checking account. That does not get reinvested. It does sit in the checking account. I did ask the question of Ryan, and he's going to look into it, is if we could invest the funds in the checking account, because we don't earn any interest on them right now. So if we could take those funds and invest the dividends and interest to gain more dividends and interest and not have that be taxable to the elders, that would be another way to increase those checks. Or we could take those funds and put them back towards the base. So we could have options with regards to that.
Okay, thank you. Isaac?
Holly, how much are we talking about?
Well, let me go into, I'll explain what
Hey,
we get.
Yeah, and I have one other thing, and I want to make a recommendation. Hopefully, we can move to some type of electronic disbursement in the future instead of just plain old handwritten checks. So I'm hoping yous are looking into that.
Well, I think that may be more of an option with our new software update, and hoping that that will be something that we can do. Of course, that would require us to obtain everybody's routing number, bank account.
For thousands of elders.
Yes, for thousands of elders. Then we would have to run a file to make sure the integrity is accurate and everything is correct. But right now, our system cannot handle that. Going forward, hopefully, with the new software update, we would be able to do something along those lines. So I also don't know how many elders would be in favor of that versus not, and maybe you do as the board. Maybe they've advocated for and or discussed that with you. So we would need to look into that. But anyways, right now as it sits with our investment, we're gaining roughly anywhere between 3 and 4% on our investments. And I think what Bill was going to touch on earlier is with regards to the loans that we have out there. So we have one for St. Agnes. Well, we actually have two for St. Agnes, one for Greektown. Those are currently at 12%. We have one with 860, which was for the old motor pool building up on 3 Mile. That is at 7%. And then we have one with Eagle Lending and one with Dem Wadding, and those are at 3%. So we currently do not recommend paying off the 22.3 million that's loaned out for the Greektown and the St. Ignace. And the reason why is because those funds go directly into the checking account to pay. And if you were going to look at that, you get roughly 2.7 million coming into the checking that's used to distribute to the elders. And if you were to put that into the base and then look at the percentage that we gain off of that, you would not have nearly that much money. So that's one thing that we're not going to recommend at this point. We did look at some other options. We have some settlement funds and things of that nature. I believe at one point there was a directive related to the jewel funds maybe, but those are restricted, as are some of the other settlements we looked at, so those are not going to be options. The board, if the board agreed to, we could do some funds from tribal support to the base. I think it's important to note also that with that 2.7 million that comes into the checking account, that directly comes from cost center 1173. And so that pays the interest on those notes. And that is also part of our overage when you're factoring in tribal support. So when we say we were 4.6, we can also say that of that 2.7 is part of that amount.
Good, Isaac.
Hey, that Jewel resolution, which I sponsored, is still in effect, so we should probably resend that.
So are you guys saying there's restrictions in how we can use those funds per the lawsuit?
Yes, from my understanding and working with Ryan, there are.
Okay.
So the one way that we could accomplish taking any funds from tribal support would be to find the programs that we could utilize those funds for. Again, and then apply the BIA, some of the other things, any of those other, right,
So
and
if you have
reducing.
tribal support funding a program that the Jewel settlement funds could fund, substitute those funds with Jewel, and then use the tribal support, which doesn't have any obligation requirements, to make an investment into the land claim fund.
Correct. So.
Yeah, that's a great idea.
Unfortunately, that's where we're at right now, until we get to maybe a different position.
Okay, Aaron.
So contract support costs, what's the amount left?
In the contract support costs, so let me see.
Original settlement and then ongoing.
We have almost 700,000. We have $699,700.14 right now.
So we've been spending it.
We have.
Okay.
The
It used
Rama.
to be 5.5 million.
The Rama settlement is at 2.3, the Jewel settlement is at 2.8, and the opioid, I had that in my last board report. And it was, yeah, it's listed as almost 5, but I do believe we have less than that right now. So, but that would
Contract
be,
support, it's only 700,000, but that's pretty flexible though. That could be backfill, just like we do for a third party. That could backfill health related. No, it's bigger than health. Contract support cost is bigger than health.
well,
We have
this,
a portion that's health, but then we have general contract support, but if
Yeah.
the total is 700,000.
well, the 700 is for the health, I believe. So that's the IHS contract support. So when I asked Ryan about that, he said that would be treated similar to third-party revenue,
Okay.
right? So,
I was on the contract support costs settlement work group.
Kim.
If we were gonna, like, supplant the Jewel settlement into these contracts and have extra tribal support, I'm not sure if I'm understanding this right, but why wouldn't we balance our budget with that?
well,
I heard so much about how much we were in debt
well,
last year. Are we balanced?
we were 4.6 over,
So we're in the negative.
correct.
So why wouldn't we take the tribal support and take care of that before, and then get ourselves good again, and then we could start putting money into the elders?
We still have a fund balance in tribal support,
So,
but I would never advocate to just utilize those funds, right? So,
How much is that again? That's not proprietary, is it? The fund balance? Public record?
People report it all the time. A lot of times they report it inaccurately. You know,
Right,
like
'cause
what
it
you should be
was-
asking is how much cash on hand do we have, not in the investment accounts or anything like that. Like, it was reported, I think, at the last meeting or two, we had like $50 million in the fund balance. The real question is how much cash on hand do you have?
we put a majority of the funds into investments and move them regularly. We try to let everything incur interest,
well,
dividends,
I
and
just
earnings.
remember in like November and December how some of us were getting our butts chewed because we were 18 million in the hole. I heard that over and over, and then come to find out we were down to 3 point something? 4.6, okay.
I
You
agree
know,
with you, Kim.
You
know
know,
what
and
I
I
mean?
kept hearing, we gotta
Yep.
balance the budget, balance the budget. So if we have money we could do that with, let's do it. And I know we do have a fund balance, but that's
It's not
our
unlimited.
safekeeping,
Yeah.
right? Right.
Yeah, so I don't think we've spent a whole lot of those funds. Like when you look at opiate settlement funds, Jewel has just been sitting there, so I agree with Kim.
Yeah, and Isaac brought that quite a
Yeah,
while ago.
like with our budget issues, we should be identifying, certain programs and services within the tribe that's eligible to use those funds for that we're currently paying with tribal support. Therefore, we can hold on to those dollars because they're unobligated. You can spend them on whatever, so 100%.
And that's what we've been doing. Like you'll see, there will be a budget mod coming forth for almost $900,000 to replace tribal support and utilize other funds.
See, so once we get that taken care of, then whatever we have over it, we could start putting into the elder fund.
Yeah, and that would be the idea, but we could move those funds to offset the tribal support, look and see what we have, and then make a decision on if there's funds to
See
move
what's
them in
left.
there, right?
Yep. Thank you.
Okay, any other recommendations that you guys can make regarding this topic? Anything else to add? Okay, go ahead, Kim.
How many elders did we pay this year? I think you started saying it and one of us cut you off, yeah. I tried looking, but my thing won't only let me search back a month. And enrollment was talking about the direct deposit for the checks and trying to figure out how that could be done.
Just 1 second, Aaron.
Yeah.
Do you guys have that information?
Is that it right there?
The projection was 9045, but it depends on who registers and then who actually gets the check.
Does that sound accurate? Okay. Well, while they look up that information, go ahead, Aaron.
So I was going to say, I remember the time when we moved to direct deposit,
Although those could have been additional.
and our team members were all up in arms about it. This was in 1992. They did not, remember when you were in high school, but when we moved to direct deposit, people were furious about it. Lana will remember this. And they required it to one institution, right? So there must have been a kickback involved, but we didn't think people would want to do it. But after about 2 years, it took about 2 years, then people were like, oh, I like it better this way. I can track my expenses. I think we are at the tail end of the baby boom, and I think there might be some older elders that may not want to do it. But this notion that our elders are computer illiterate and they don't know what they're doing, that's a total misnomer. Because our elders go online. They're some of the biggest critics. I think that as long as we don't mandate it, if we allow for it and then transition a couple of years, 3 or 4 years down the road, everybody's going to want to do it. So, and it would allow them to be able to, well, then if we really get smart, we could do electronic, like an email out, just click this and then you're registered, because we do have trouble with people who are snowbirds, who don't get their mailing, and then that's why we don't have a cutoff, because we know we're reconciling elders calling, into June or July, calling about their elders. Oh, I forgot. I'm sorry, I forgot. And it's only $300 now, so it's easy to forget. It was $1,600.
So, Bill, do you have that information?
Yes, I do. We paid 8,482 elders, each received $340.
What was that number?
8,482 elders, each received $340 for a total of $2,883,780.
And again, the interest of the account is simply divided by the amount of elders you have. So if you have a relatively stable interest rate, that's producing about the same amount of money, the more elders you have, the smaller the check goes down. Simple
Yeah.
math problem.
In addition to the earnings that the fund has from interest, we also take any realized gains that the investments have earned as well. So
Okay,
there's usually a
appreciate it.
couple $100,000 there, give or take.
So anything else to add to the conversation before we finalize it with the board?
Mr. Chair?
Yep, just 1 second, Aaron.
I guess there's a discussion, I suppose, and I don't know if this is with regards to maybe any of the properties that we have that are assets of that.
Sibley?
Correct.
Exactly, do something with Sibley. So we had it appraised, I'm not gonna mention how much, but, it's worth several $million, not as much as we initially thought, you know, when we decided to send more money to the developers in the JLJ case, but we're doing nothing with that property. So I'd be supportive of selling it to buy additional land up in the Upper Peninsula, sell it to supplement the Elder Fund. So, absolutely. Aaron?
The original elder amount number was about 2,100 in 2000, and Denny was the one that always reminded us of this. The baby boom, and we're about 9,045 elders, that was the number. But you can see that we paid 500 less than the total number of elders that we have. That number is going to be more because of the enrollment, the open enrollment, because it was mostly elders that are enrolling. But the effect of the baby boom is tapered now. So we're kind of past that big impact. So it is becoming more stable. And the other thing is that even to this day, if an elder didn't fill out their form and they are listening to this now, we won't deny them. They will be permitted. They just call accounting and they can fill out their form and then they can get their check. That's why it's in the checking account, so that we have the money to pay the elders. So
They can call enrollment.
one of the best things we ever did.
Okay, any final questions, comments from the board on this topic before we move on? All right, thank you so much, I appreciate it. The next item that we will workshop is cultural enhancement funds. We're gonna have a discussion about that. So this is fast becoming one of the most talked about items. We've workshopped this many times. There's been many resolutions on the agenda. Sometimes we'll put them on there without workshopping. Whatever reason, it doesn't pass. So the last time we talked about this, it seems like a compromise was in place. It seemed like there might be support to publish in the tribal paper once a quarter when we publish board travel, how much funding is in each unit's cultural enhancement coffers, along with what projects were funded in that last quarter, along with what projects are scheduled, along with possibly, I guess an application wouldn't be the correct word, but maybe like a cutoff in each quarterly newspaper where a tribal member can cut off a section of that paper where it lists name, phone number, what type of cultural enhancement workshops that you might be qualified or interested in putting on for the tribe. And then that can be maintained either by the board office or the cultural department. I think that's reasonable, it's transparent, doesn't go too far. I think it's a good compromise. And I really don't need an hour to talk about this at this point. I mean, this has been an exhausted topic. Aaron?
So when we have a separation of powers, the whole issue of an appropriations or not an appropriations, we have a budget. And to me, when we had this discussion, it was like a little smugness last time. It's like, almost like a sleight of hand. We don't appropriate the funds on an annual basis into a budget that we then spend from that budget. We have a revenue account from the sales tax. We get a report on it. It goes into the account. But we don't, on an annual basis, vote to establish a budget for the cultural enhancement. It happens after the fact because the revenue comes in after the fact. Or let me ask it as a question, like a Jeopardy question. Do we know how much we're going to have for that year? Do we appropriate and create a budget for the full amount for that year for cultural enhancement? Right, that's why I'm wondering whether or not we actually enact an appropriated budget. And if we do, I'd like a copy of that budget in the cost center. Because I don't think that's the way we do it. I think we have a revenue allocation, a revenue accounts receivable, and we put the money in the account. We have a separate account we created as a budget, but I'm doubtful that at the beginning of the year, it has an appropriations for the full amount. Because we get reports on a regular basis of how much funds are being transferred over. So I guess which is it? That's just one question or one point I wanted to make.
Okay, for 2025, let me just shift this one real quick. the budget for revenues into the fund was 245,000. The actual receipts, and these come from the, as I point out every month, these come from the 3 hotels, the 5% tax on the cash revenues of the 3 hotels, motel, was $221,122.
So that's AR into the account?
Yes, and then that's divided up by 5, and each unit gets the same equal amount.
Okay.
And then from there, their expenditures, of course, would be different, but so they are taken against that, and as we talked about earlier, then I just keep a rollover of the balance. I don't treat it into fund balance, I treat it as a deferred revenue by unit.
All right.
So that any one time or any one end of the month, we all know, or I know exactly how much each unit has in their so-called bank account.
So we, just so I understand, so we establish a budget, and then it's like doing drawdowns from a commitment. But the drawdowns don't happen until the money's realized. When we get the money from the hotel tax, then we deposit those in, and then we spend them along the way as board members sign off on requests. Is that correct?
Essentially, the first few years of the fund, Aaron, the expenditures weren't anywhere near what the revenues were. So each unit's share built up. And so like in 2025, the expenditures were more than the dollars that were taken in as revenue.
And more than what was budgeted?
Yes.
Okay, there's exactly, I mean, that's the point. So if this was a lawsuit and it was reconciled in a lawsuit, we cannot spend as a board. You can't spend money if it's not appropriated. You can't. You don't have any authority to do that. The board doesn't have that authority. The staff doesn't have that authority. So this is, I'm in the severe minority on this issue. So it's going to be something that we just kind of skip past like a rock across water. But when we do have a separation of powers, then the membership will have the ability to reconcile and correct it, and it will be done correctly. But all right, so that's my first point. My second point is years ago, Christine and I teamed up on this. She was at the time our tribal social services. No, she was executive director, and we were failing to comply. And I won't use any names, but we were failing to comply with the BIA's requirement for background checks for children and for people that had access to children in the delivery of service. The board made a decision at the time, and I was on the side of this decision, to protect the children of our tribe, and we took a step that was probably beyond what we needed to do, and we prohibited people that had assault charges or any charges that could be argued to be in violation of the BIA requirement. But to be very clear, we were not in compliance with the federal government's law with background checks. So we developed a procedure, and the board passed a policy that required it. Okay. The use of cultural enhancement funds has no background check at all. There's no volunteer clearance at all. And so it's possible, and I know it's actually happened. We do have people that have been indicted for crimes that would prohibit them from working from children in the tribe. And I have to believe that given they were indicted, they're also on the registry that would prohibit them from having access to children that do have access to children during cultural enhancement workshops. And I have a really, really big problem with that. You know, we talk a lot about MMIP, we talk about victim services. You know, we have a commitment in this area, but we have a loophole where people who do cultural workshops are not required to go through any background check process. And for anybody that's listening, I'm getting some looks already, but I'm not lying. If there is a background check process required, Can I get a copy of it? Can I put it, I'll put it in my unit report the next month, so you can see if there's a background check requirement, because there isn't. There is not a background check requirement. And having said that, on the cultural side, cultural division, we used to follow that, but I'm seeing that we do have people that have been indicted for CSE with a 8-year-old minor who are now having access and providing cultural workshops through our cultural division. For a while, we were kind of insulated there. There was amnesty and protection through, if we're providing the service, we were following the volunteer background check requirement. And now I'm concerned that we're not, because I'm not going to give you any hint of any names or any unit, but one unit, I thought it was the cultural enhancement, which there's nothing I can do about it. I mean, I brought it to the table. I've passionately talked about it. You know, it seems inconsistent that we talk about protecting victims, but we don't have a background check on cultural enhancement, but I'm outnumbered right now. So, but then I noticed that it was not, because my first response was to reach out to that board member and say, what the hell are you doing, right? But that person said, I didn't do it. It's not cultural enhancement. It's the cultural department. So number one, this would be for Jessica, if you can share it with Jessica. I think the cultural division is not exempt from that background check requirement. If somebody is on the registry for having molested a child, or if they have a indictment, they would not be able to work through our cultural division, putting on cultural workshops for minors. That's number one. And again, I'm outnumbered on the cultural enhancement, but you know, I think it would behoove us to enact policy that would ensure that somebody that has been indicted doesn't have access to our children. I don't even, to me, there's not even another side of that argument. So, yeah.
Okay,
And-
guys, so let's try to create some solutions with this. So if you do a background check, all it's going to check is convictions, so anyone can be charged with something. So we have to keep that in mind.
As a social worker, you also know that if you need to work in any positions related to social work, you cannot be on the registry either. So we should check, background check and registry.
So you're referring to DHS's central registry, so that would only be in place if there's a substantiated child welfare complaint. So again, it has to go beyond an allegation. There has to be, you know, finding of proof that the allegations occurred as substantiation. So let's try to keep things solution focused. So again, this topic has been on many agendas. We've workshopped it many times. And the last time we talked about it, I'll give you guys a refresher. It seemed like there may be support to publish in the tribal paper once a quarter how much funding is in each unit's cultural enhancement coffers, what projects were funded in the last quarter, what projects are scheduled for the following quarter, and a basic application where someone could cut something out of the tribal paper, name, date of birth, phone number, you know, basic contact information, along with what types of cultural enhancement services that individual is interested in putting on. That way, the cultural department or the board office could maintain that. So if you're a board member and you want to put on a type of workshop, you could call, you know, the cultural and language director, or Lana Stewart, and be like, who's out there in the community that's interested in putting on workshops? That way it can be fair and more people can have an opportunity to provide that. So let's just keep it on that. So Rob, then Tyler.
Okay, so I co-sponsored. I will first say that I do not think this goes far enough whatsoever. But after the last couple refusals to do the right thing and redirect the funding under the proper department, which would be the cultural department, it sounds like this is the very least that this board is willing to pass. So at the very least, I'll support it and give the membership the right to view what we're doing. But at the end of the day, like, I will stand by my original comment that this is an unconstitutional action. And whether there's a resolution to appropriate it or not, it doesn't negate the fact that our Constitution is pretty clear, and our code is also clear, that there needs to be 5-day notice to our membership before we take action or spend funds. And that does not happen during this process. You know, I bring forward a lot of cultural enhancement requests because this is the process that's laid out, but I don't agree with it. I'm not going to not do what my members advocate for me to do within our community because I don't agree with the process, but I am going to do everything I can to change it and to tell the members the truth about this. The truth is, there's not a single elected official on this board that's a culture expert or even qualified to do it. I mean, none of us would probably get the job of cultural director if we're being honest. So we have a department for it. And it's absolutely improper for us to vote outside of our membership's viewing of where these funds are going. In no government would this be acceptable for government to have carte blanche authority over funds. These funds are not ours; they belong to our members, and our units shouldn't depend on whether we're going to win our elections or not to determine how culture is going to be administrated in our units. And I really don't think any of us should have that authority. I think that we have a department for a reason, and they could better utilize the funds. And like I suggested before, that it would be advisable for our culture department to meet with each unit so it's specific to the community and their needs, and give members input. I mean, the directors can sit there in that meeting and give input equally to our members, but we shouldn't be above our members. And that's really what it is just we get to decide where these funds go, and it's happened to be done for political reasons over the years, and no one could argue that it can't, that it hasn't. So I'll stand by this. This is unconstitutional to me. I don't think this goes far enough, but you guys made it very clear in the last couple meetings that doing the right thing is off the table. So I guess this is the best the members can get, and hopefully they send us a very clear message that they're not happy with this. I'm going to support it because this is the least that we can do, and it's going to give at least some kind of notice to the membership, but it's not enough. And so I hope the members lash out at us for not doing enough in this. I'm going to support it, but when it passes, I'm going to be clear with the members that this isn't what I intended. It's just the least that we can get right now, which is sad.
Okay, Tyler, then does anyone else want to speak on this topic before we move on? Okay, Tyler, go ahead.
Yeah, so I'll co-sponsor what you presented, Austin, but I just want to add one thing to make sure that we're capturing this correctly, is that so not everything is allocated towards a specific workshop itself. So for instance, I know many people have bought in storage units, shelves, things of that nature for some of their cultural supplies. So we bought a storage shed in Munising, and that helps store some of the powwow supplies that were in a previously rotted shed in an unsecure property. But I think we need a line item that captures supplies or miscellaneous items with just a brief description. So if you could add that in there too, so that doesn't get missed. So, if we spend 10,000 in the month of June or something, or July or August, whenever the powwows seasons begin for each of your communities, and some of that is storage or not necessarily fully related to the powwow, it's still getting captured, so it doesn't look like things are going missing, right? So we still want to capture that, and I just want to make sure that that's put out there.
Yep, that's a good idea. So, Ryan, could you draft that resolution? If anyone would like to co-sponsor it, just get a hold of Lon on that. So let's take a 5-minute break, and then we will go into close to have a discussion about a couple things. So 5-minute break, and then we'll reconvene. Go ahead and make our way to our seats for agenda review. Agenda review won't take very long today, so afterwards we'll have a long break before the meeting. So a lot of the resolutions on tonight's agenda we've workshopped several times. I asked Lana to cross off the resolutions that we don't need to cover for agenda review. The first one that we do need to cover is titled Contract with Chippewa Loose Mackinac Conservation District for Invasive Species Treatment. Danny, could you explain this to the membership, please?
Yep. Hi, everyone. My name is Danny Fagan. I'm the director for the Natural Resources Division. This resolution is authorizing a contract with Chippewa Loose Mackinac Conservation District to do a lot of the manual labor related to invasive species treatment in the St. Mary's River. This is nearly impossible for us to do with a crew of 2 that are actually in the wetlands regularly, and so this is the most cost-effective way to do this, and comes from BIA Great Lakes Restoration Initiative grant funding.
So you guys, Wade, we're trying to listen. We can barely hear up here. So Aaron, the microphone is right next to the speaker. It doesn't get any louder than that.
It's one of these, because that mic doesn't, does the owl echo here? These ones are the ones that you have to use to echo, isn't it?
No, there's
We got it set
speakers
up.
right there.
Yep. So
And that's what these mics are attached
yeah,
to.
it's set up the best that we can do. So any questions or comments for Danny on this resolution?
You're muted, Charles.
Unmuted.
We're not muted.
You were.
Okay.
Oh, shoot, we are. Son of a gun.
So any questions or
It's good
comments for
now.
Danny on this resolution? Okay, thank you, Danny. Appreciate it.
Thank you, Danny.
Okay, so we'll move on to the next resolution, which is approving construction contract with North Superior Property Service, and Andrew Lane is going to cover this for us.
Yeah, hi. This is just to award the construction contract for the powwow grounds down on Sugar Island. It's installing a 4 stall vault restroom facility, a small 16 by 8 utility building that will provide like a 3-stage sink for the participants to wash their dishes. We're putting a well in and a drain field and a septic tank. So that's what this contract is going to do.
Yep, and this is an ARPA-funded project. Any questions or comments?
Can you ask them how much of the remaining ARPA dollars are left?
So Andrew, after this project is complete, are there any anticipated ARPA dollars that will be unspent that were allocated for this project?
Yes, there should be dollars that we are underspent.
Okay, thank you. Do you know the amount offhand, provided we don't have change orders?
I had this figure, should have had that ready. I will have that ready and I'll send it to you.
Okay, thank you, I appreciate it. All right, let's move on to the next resolution, which is acceptance of the 2025 Kuwait Casino audit. So we handled this recently. Bill's here to answer any questions if you guys have any. And we passed it in the Gaming Authority meeting. Any questions, comments? Okay, so hearing none, we'll move on to the next resolution, which is acceptance of the 2025 Kuwait Casino Gaming Authority audit. So this would include like iGaming as well. So any questions here? Okay, hearing none, we'll move on to new business. Committee appointments, you guys have them in front of you. Any discussion on those? And then we have Conservation Committee appointments. So we have 4 vacancies. 2 of them will be filled from non-fishermen. From the commercial side, we had 3 applicants. We can only appoint 2 commercial fishermen to that seat, so 1 fisherman won't make the cut. You know, and we know which ones are supported because we had a workshop prior. I would encourage that fisherman to keep an eye on the vacancies, because we have vacancies every single year, and keep applying. Any conversation there? Okay, does anyone want to talk about their board concerns right now, if you have any, just to make good use of time? Okay, anyone? Kim? All right, so let's go closed right now, and then we'll cover Kim Gravel's closed session board concern. to go ahead and call this meeting to order. Let's start with roll call, please.
Sean.
Here.
Alana.
Here.
Isaac.
Here.
Kimberly Hampton.
Here.
Aaron Payment.
Here.
Michael McCurchie.
Here.
Rob McRory. I just let him in on Zoom. Kimberly Gravel.
Here.
Larry Barbeau.
Here.
Bridget Sorensen.
Here.
Tyler LaPlante. Kimberly Lee. Austin Lowe's.
I'm here. So we have a quorum. Are there any objections to adding
Hey,
commercial?
guys, I have no audio. I don't know if anyone could hear me.
I can hear you.
Reboot. Oh, I'll tell them.
Okay, so can those of you on Zoom hear us?
I can now, yep.
Okay, all right, awesome.
Yes.
So, are there any objections to
video.
adding, guys? Are there any objections to adding commercial fishing license to today's agenda? It would be the last item under new business. Okay, hearing no objection, we will suspend the rules and add that under new business. On today's agenda, we have the following items. We have invocation. Do we have someone to do invocation? Yes. Okay. So we have invocation, membership participation, the approval of minutes from 4/7 of 26. We have the following resolutions. The first is titled IT FY26 Budget Modification, Telecommunications FY26 Budget Mod, PRC FY26 Budget Mod, Sioux Medical Nursing FY26 Budget Mod, Establish Health Expansion FY26 Budget Mod and FY26 Third-Party Budget Mod, Invasive Species Contract with CLM Conservation, Approving North Superior Construction Contract, Accept 2025 Kuwaitan Casino Audit, Accept 2025 Kuwaitan Gaming Authority Audit. Under new business, we have committee appointments, we have conservation committee appointments, we have commercial fishing license, and we have board concerns. With that, is there a motion to accept the agenda?
Motion. Support.
Motion from Isaac, support by Larry. Any discussion on the proposed agenda? Hearing none, those in support signify by saying aye.
Aye.
Those opposed? Those abstaining? Motion carries and the agenda is adopted, which brings us to our first item, which is invocation.
Great Spirit, we ask you to bless this gathering of friends and family. We ask you to help our board make wise and fair decisions. We ask that you thank Mother Nature for the nutrition that you gave us to help our bodies grow strong and healthy. We ask that you would help our elders that have walked on and help them on their last venture in life. In Jesus' name, amen.
Hey, thank you, Tom. Much appreciated. So I'd now like us to offer a moment of silence to two tribal members that recently walked on. The first is Trevor Mounts, and the second is McKenna Smith. What's your last name, Kim? Carlson. So if we could observe a moment of silence, I'd appreciate that. Miiglich, thank you. The next item on our agenda is membership participation. So as tribal citizens, you have the right to talk to your elected leaders. This is that setting. We give 5 minutes to individuals when they need to speak with us. If you need more time than that, someone from my office or somewhere else in the tribe can give you a call tomorrow morning. Couple rules, as mentioned, we give 5 minutes just because we have a busy meeting. and a lot of times there's a pile of people that want to address us. No profanity, no yelling, no swearing, no singling out individual board members, attacking, things of that nature. So I have a stack of forms right here. First tribal member that can speak for us would be Mr. Larry Godfrey. If you want to come up, sir. Can someone set that microphone up for him, please? Thanks, Damien.
Push it to top. I'm all set.
You're good to go.
Okay.
When you get close to 5 minutes, if you do, I'll point to my watch. That way you know what the
I
time
ain't
is.
gonna worry about it.
All right, sounds good.
All right. Can everybody hear me? I can't hear you. I'm hard of hearing, so that's gonna be a problem. Question I have. The traditional medicine room in Escanaba gets used twice a year if he doesn't cancel. Why is there such a restriction on it? If we wanted a sacred fire and inclement weather, and in fact, they have them out in the parking lot now. There's a beautiful place for a sacred fire in that room, but yet we were told we can't use it. Part of the reason this all came about, that drum that you brought over to the center, rather than putting it in a storage room or a closet, we kept it in that room. Somebody, whoever, took offense to it or whatever. There was no traditional medicine person there at the whole time it was in that room. But yet we get a letter saying it's gotta go. So it's in a storage room now. My question is, why can't we use that room? If we do ceremonies, it isn't a big room. We don't have a big turnout of people there anyway. But that room is the perfect spot to do other ceremonies. Why such a restriction?
Okay, I appreciate it. Several of us have been in communication with the Health Division on this topic. Mary, can you contact the Health Division CEO, get an update, and then contact Mr. Godfrey tomorrow? Because an answer is waiting there. You just gotta call him up, get an update. So we'll get you an answer tomorrow, okay? All right, thank you so much. Appreciate it. We'll get you in there. Next up, Ernest Emmon.
Bojo Kenawaya, Bojo Kenayanda Nawe Maganadok. I stand before you today to ask about our community center, a place built where our community members could gather, learn, heal, and share the teachings of our ancestors. But when our ceremonial room was taken from us, something deeper was taken. For a community, a ceremonial space is not just a room, it is the heart of the community. It is where we honor our ancestors, where we come to learn who we are. We are a people with a spirit, a history, and a responsibility to those who come before us and those who will come after. When that room was removed from our use, our community lost its heart. A place where we can share joy and grief. A place where we simply sit quietly together and remember that we are all related. I ask the board to restore the ceremonial room to the Escanaba community. When we protect our ceremonial spaces, we protect the heart of our people. Miigwech.
All right, thank you. Could you also update Mr. Demon as well? Okay, thank you. You'll get a call. Okay, thank you. Next up, Kelly Hattinger.
Well, I brought this up several times, and I really never get an answer. So I don't care about other areas. I only care about our unit on this. We have an emergency shelter built. We have emergencies, it's never open. I mean, we'll use the snowstorm that we just had. We had critical workers that had to get to work, and the highway was open enough for them to get from here. They could have stayed there. I heard one girl slept in her car. People didn't have power for how many days? I don't understand why we build emergency shelters if we don't have a policy in effect. I brought it up a year ago when we were here. So maybe as a board, we could have a workshop on it and maybe set up a simple procedure. I mean, I get maybe it's staffing, but you know, you don't build a center for emergencies and then not use it. Thank you.
Okay, I appreciate it. We'll work on it. Mr. Wade Jensen.
I just got a question. My question is, do we still belong to Cora? Why are we belonging to a place where we never had a voice? We never had no voice down there at all. Not with the state, the feds, or the other 4 tribes. I mean, absolutely no voice. And then to go to court to lose the way we did, where the courts wouldn't even take us serious when we did it. So that's why I don't understand. Why are we still at Cora?
So Mary can give you an answer on that as well. We do have a core meeting on Thursday. It's open to the public. I'm going to be there. If you want to make it down, Wade, I'd love to sit next to you.
Well, like I said, I don't understand why we're there. If we don't got a voice, what's the purpose? Because how it stands right now, we have no voice there. And why don't we start going like Little Traverse and don't pay our dues? You know, there's things we can do. You know, if they're not going to treat us honestly and fairly, you know, at one point we were the biggest fishing tribe out there, and now it's switching back and forth from us to Bay Mills. You know, it makes no sense what's going on. You know, and I hear you're going about the fishing stuff, the exotics or whatever, the diseases with the fish. In '97, the salmon, the disease spread from the salmon. It was a kidney disease. In 1997, 77% of the whitefish got a kidney disease. It's been one problem after another. It's like they're the ones causing it to get their sport industry and their sport dollars and all this stuff, but the commercial industry is the one that's taking the hit. The next thing is, these trout refuges on Lake Michigan and Lake Huron, why do we have them? Them are introduced species. The original lake trout is not what they're planting. It's something new. You know, it's like, you know, it's like when we were, the walleye. We had to test the walleye to be able to plant the walleye in Big and Little Beatty Knock. You know, the state couldn't even plant them because they weren't testing the fish. Well, we got all these private organizations and everything else dumping these fish in, and we don't know if they're contaminated with some kind of disease or fungus or whatever, what's going to affect us in the long run. And that's what's been going on for quite a while now. And, you know, and it's like without a voice, you know, Cora's supposed to be our voice. There's no voice. Thank you.
Okay, I appreciate it, Wade. Would anyone else like to speak to the Board of Directors? Okay, then I'll move on to the next item then, which, yeah, go ahead. Thursday. Yep. Am I going to see you down there? All right. All right, so let's move on from membership participation to minutes. I'd like to entertain a motion to accept the minutes from 4/7 of 26. A motion from Lana, supported by Isaac. Any discussion on the minutes? Hearing none, those in support signify by saying aye.
Aye.
Those abstaining? Those opposed? Motion carries. Thank you. Those minutes are adopted. That brings us down to resolutions. The first one is IT FY26 budget mod.
Is it the internal services? Oh, yeah, it is. Never mind. Be resolved that the Board of Directors of the Sault Ste. Marie Tribe of Chippewa Indians hereby approves the FY 2026 budget modification to telecommunications for a decrease in other revenue of $889,034.10, an increase in tribal support of $95.83.
Motion. Support.
Motion by Isaac, supported by Larry. Bill Travitz, could you explain this resolution to our membership, please?
know if Bill's on, but
I was
I'm
about
on.
to say, how about Nick Eitram?
Yeah, I'm on here. So what we're doing, Austin, is we are evaluating a couple of positions within the IT department here and just trying to keep things up to date so that we're not stagnant and falling behind as far as support staff for our IT as we move into quite a bit of new infrastructure that we're putting in right now.
Okay, much appreciated. Any questions or comments on this resolution from the board? Okay, hearing none, those in support signify by saying aye.
Aye.
Those opposed? Those abstaining? Motion carries. Thank you. The next resolution is Telecommunications FY26 Budget Mod.
Be it resolved that the Board of Directors of the Sault Ste. Marie Tribe of Chippewa Indians hereby approves the FY 2026 budget modification to telecommunications for a decrease in other revenue of $3,857, an increase use of fund balance of $57,677.76.
Motion.
Motion from Isaac,
Support.
supported by Larry. Nick, could you cover this as well?
Yep, so this is, every year, the telecom budget updates aging switching equipment within our organization, and it just wasn't included in the budget this year, so that's what this is. And we're replacing 25 switches throughout the Sault Tribe with this money here.
Okay, I appreciate it. Any questions, comments on this resolution from the board? Isaac?
Hey, Nick, you said last time at the workshop, we're going to be using Fortinet switches eventually?
Yes, we are looking into Fortinet switches to see if that would be a good fit for us, so that we're not always locked into just one vendor.
Are you going to bench test them prior to purchasing?
100%. We want to test them in a couple of smaller areas before we roll them out to bigger areas.
Okay,
But
thank
we
you.
would, even before that, we would test them here in the office.
Thank you.
Anyone else? Okay, hearing none, those in support signify by saying aye. Those opposed? Those abstaining? Motion carries. Thank you, Nick. Appreciate it.
Thank you. Have a good day.
You as well. The next resolution is PRC FY26 Budget Mod.
Be it resolved that the Board of Directors of the Sault Ste. Marie Tribe of Chippewa Indians hereby approves the FY 2026 budget modification to purchase referred care for a change to the personnel sheet.
Motion by Isaac, supported by Larry. Carrie, could you explain this resolution for our members, please?
Mr. Chairman, this one will be from me. This is the PRC. This is James.
Okay, thank you.
So the resolution before the Board of Directors for consideration will allow us to go ahead and hire another PRC coordinator.
Okay, I appreciate that. Any questions, comments from the board? Isaac?
Hey, James, this is Isaac. Hey, can you give us a list of how many patients and the amount of actual claims that are out there?
So for the FY 25, the numbers for the total amount of members was 4204. Number of vouchers, 45,454.
So based on the amount of caretakers that you have in place, how many patients do they have to take care of, like each provider?
I'm sorry, you're saying per provider? Per coordinator, is that what your question is?
Yes, sir.
So I can tell you going through A through C was 827 members. D through H was 873 members. I through MC was 921. ME through R was 754. And S through Z was 829.
Thank you.
Aaron?
I just want to say, this is always an area that we have to improve, but I want to say I've had the experience in the last several months of using PRC, and our team members are very compassionate. They're very supportive. It is confusing when you have to use something that's going to save your life, and they're just amazing. Kim Menard especially, I want to put in for Kim Menard, but so whatever we can do, though, to make sure that the workload is manageable, because I do think that they have a giant workload, and the quicker we can turn that around and assist patients, but I have no complaints about how compassionate and caring they were in my access to PRC. So thank you, James.
James, could you repeat how many PRC claims were processed in the last year?
number of vouchers for FY '25 was 45,454.
45,000, that's really impressive. And, you know, if you have a very small percentage of error, you're always going to have, you know, people here and there that don't have a good experience. Maybe, you know, vouchers, they get lost in the shuffle, but 45,000 is truly impressive. Kim?
Yeah, can you repeat the patient load that you had said per PRC coordinator?
Sorry, the connection's not good. I believe that you're asking for the patient load per coordinator. I'll go through the letters of the alphabet. So A through C was 827, D through H, 873, I through MC, 921, ME through R, 754, S through Z, 829.
Thank you.
Anyone else? Isaac?
Hey, James, I know we have talked about this extensively, you and I, but I know that you had mentioned, and I just want to put it out there to the public that, you know, our caretakers are at the mercy of the other agencies. So like My Michigan, if they drag their feet, then it makes it look like we're dragging our feet, which is not the case. But there is a process in place, and it takes a long time. And I think that process will be a lot better when a new EHR system is installed, because it'll be more electronic stuff. So I just want to thank you and your staff. Thank you.
I appreciate that. I can let you know that I'm also meeting with the CEO of My Michigan, I believe it's next week, to talk about PRC and some other issues.
Okay, anyone else? Okay, hearing none, we shall vote. Those in support signify by saying aye.
All right.
Those opposed? Those abstaining? Motion carries. Thank you. The next resolution is Sioux Medical Nursing FY26 Budget Mod.
Be it resolved that the Board of Directors of the Sault Ste. Marie Tribe of Chippewa Indians hereby approves the FY 2026 budget modification to Sault Ste. Marie Medical Nursing for changes to the personnel sheet.
Motion.
Motion by Isaac, supported by Larry. James, Carrie, will one of you present on this as well?
Yes, hello everyone. This is Carrie Rogers, Clinic Manager here at the Sioux Tribe Health Center. This is just a budget modification to add another IT health technician to the medical nursing budget. This will help with the implementation of our next gen EHR upgrade, as well as other projects moving forward as well.
Thank you. Any questions or comments from the board? Seeing none, those in support signify by saying aye.
Aye.
Those opposed? Those abstaining? Motion carries. Thanks, Carrie.
Thank you.
The next resolution is Establish Health Expansion FY26 Budget and FY26 Third-Party Budget Mod.
Be it resolved that the Board of Directors of the Sault Ste. Marie Tribe of Chippewa Indians hereby approves the establishment of an FY 2026 budget to Sault Ste. Marie expansion and renovations with a transfer in of funds from third-party revenue, $14,465,591. Be it further resolved that the Board of Directors of the Sault Ste. Marie Tribe of Chippewa Indians hereby approves the FY 2026 budget modification to third-party revenue to transfer out funds to Sault Ste. Marie expansion and renovation, $14,465,591.
Motion.
Motion by
Support.
Isaac, support by Kim Hampton. James, are you covering this one?
This is Annie Thiebert. I'm with James, and so I can cover this one.
Okay, much appreciated.
This budget will just create a new cost center so we can track the project funds in a more efficient way using third party.
And this will be for the annex in Sault Ste. Marie, correct?
That is correct.
Okay, very good. Any questions or comments from the board? Isaac.
Hey, Holly, I know this was one of the first, no, Holly, I'm
Oh, Holly.
asking Holly a question.
Okay.
This was one of the first ones that was in the 105 leasing program. Do you think the construction of this facility might be handled by that? Or is it too early to tell? I do believe this was one of them that was in it first, right?
The health center was put in the 105L, but not the annex. So I think we could put a letter of intent in to build this with the 105L.
I strongly encourage it.
We had also looked at the potential for financing.
Yeah. Thank you.
Thank you.
Appreciate it.
Okay, Annie, James, any response to that?
We do plan on putting the finished project onto the 105L leasing, and then the principal and interest would be reimbursed from the 105L program once it was finalized.
Okay, very much appreciated. Any more questions, comments? Hearing none, roll call, please.
Bridget,
Yes.
Aaron,
Yes.
Larry,
Yes.
Kimberly Lee,
Yes.
Michael,
Yes.
Kimberly Gravel,
Yes.
Sean, Tyler,
Yes.
Kimberly Hampton,
Yes.
Lana,
Yes.
Isaac,
Yes.
Rob.
Yes.
All right, motion carries. Thanks, Annie, appreciate it. The next resolution is invasive species contract with CLM Conservation.
Now, therefore, it be resolved that the Board of Directors approves awarding a professional services contract to the Chippewa Loose Mackinac Conservation District for the period March 2026 through November 2026 in an amount not to exceed $50,000 to support invasive species treatment in coastal marsh habitats in the St. Mary's River. Be it further resolved that the NRD is authorized to administer the contract, charge allowable costs to approve budgets and/or grants, and ensure compliance with reporting, audit, records, IP, and other applicable requirements. Be it find the result that the chairperson or designee is authorized to enter into and execute the contract and any supporting documents necessary to fulfill the intent of this resolution.
Motion. Support.
Okay, motion by Isaac, support by Larry. Danny, Katie, will one of you present on this first, please?
Hi, everyone. My name is Danny Fagan. I'm the director for Sioux Tribe's Natural Resources Division. I am joined by Katie Schultz, our wildlife program manager. With this resolution, we're seeking approval to enter into a contract with the Three Shores SISMA, which is kind of overseen by the Chippewa Loose Mackinac Conservation District. The funding that we'll be using for this comes from the BIA Great Lakes Restoration Initiative, and this funding was built into our Coastal Initiative grant proposal last year. The budget was previously approved at the last meeting. This is a cost-effective way that allows us to cover a large area for invasive species removal in a way that's doable for the division.
Thank you, Danny. Any questions or comments on this? Isaac?
Hey, Danny, do you know if the smelt's running at Nuns?
Can you repeat that for me, Chairman?
Good
Lance?
question.
Sorry.
Do you know if the
Isaac
smelt's running at the Nuns Creek?
I can't hear him.
Isaac wants to know if he can go get some smelt at Nuns Creek.
Well, I don't know if Rusty's on the call, but maybe reach out to Rusty.
I heard there's some people you can buy it from, Isaac. I want you to fall in. All right, I appreciate it. Any more questions, comments? Okay, roll call, please.
Tyler,
Yes.
Sean, Kimberly Gravel, Lana,
Yes.
Isaac,
Yes.
Larry,
Yes.
Kimberly Lee,
Yes.
Rob,
Yes.
Aaron,
Yes.
Michael,
Yes.
Bridget,
Yes.
Kimberly Hampton.
Yes.
Motion carries. Thank you. The next resolution is approving North Superior construction contract.
Now, therefore, it be resolved that the Sault Ste. Marie Tribe of Chippewa Indians Board of Directors hereby approves the construction contract with North Superior Property Services for $130,000 from cost center 8628, utilizing ARPA funding obligated in Resolution 2024-383. Be it find the result that the Board of Directors hereby authorizes the tribal chairman or his designee to execute any and all documents to carry out the intent of this resolution.
Motion.
Motion by Larry,
Support.
support by Kim Hampton. Andrew, could you explain this resolution, please?
Yeah, so this in front of you is to award a construction contract to finish out what we could actually achieve at the Sugar Island Powwow Ground. What we're looking to do is install 4 stall vault style restroom facility and a 16 by 8 utility building that will be a rustic wash station. We will have a drain field and a septic tank installed to run from that facility. It will also house anything to do with the well that will provide water to the grounds, and then there may be some electrical that is upgraded to it depending on the scope and any additional work that we can do with this contract.
Okay, much appreciated, and this is obviously an ARPA-funded project. So, any questions, comments from the board? Okay, hearing none, roll call, please.
Kimberly Gravel,
Yes.
Kimberly Hampton,
Yes.
Lana,
Yes.
Bridget,
Yes.
Rob,
Yes.
Sean, Larry,
Yes.
Kimberly Lee,
Yes.
Tyler,
Yes.
Aaron,
Yes.
Michael,
Yes.
Isaac.
Yes.
Motion carries, thank you. Next up,
Thank you.
accept 2025 Queen Casino audit.
Be it resolved that the Sault Ste. Marie Tribe of Chippewa Indians Board of Directors hereby accepts and approves the 2025 Northern Kuwaitan Casinos audit as accepted by the Audit Committee on April 9th, 2026.
Motion.
Motion by Isaac. Support by Larry. Bill?
My name is Bill Conley. I'm the interim CFO for Kuwaitan Casinos, and this is the first of two audit resolutions that we're asking the full board to approve. These came before the Gaming Authority Board last week for their approval, and that was accepted and approved, and it's been to the Audit Committee as well with a presentation at both those meetings by RSM, the casino auditors. So we're asking for the full board approval for this so that we can send the audits on to the National Indian Gaming Commission.
Thank you, and as you mentioned, we previously approved these at the Gaming Authority level. In your expert opinion, is this audit and the following one, is it in good form? Any concerns of impropriety, anything whatsoever?
No, we had a couple of small incidental findings that came up during the process of the audit related to the minimum internal control standards that they also examined, and those were rectified, and I don't see any issues with both audits being as presented.
Okay, thank you, sir. Any questions, comments from the board? Okay, hearing none, those in support signify by saying aye.
Aye.
Those opposed? Those abstaining? Motion carries, which brings us to the next audit, accept 2025 Kuwaitan Gaming Authority audit.
Be it resolved that the Sault Ste. Marie Tribe of Chippewa Indians Board of Directors hereby accepts and approves the 2025 Kuwaitan Casinos audit, which includes the downstate developments, as accepted by the Audit Committee on April 9th, 2026.
Motion. Support.
Motion by Isaac, support by Larry. Bill?
This audit expands out the previous audit to include the downstate activities and also the iGaming activities that Kuwaitan Casinos is involved in. And as I had mentioned, this has been approved by both the Audit Committee and the Kuwaitan Casinos Gaming Authority, and we're asking for approval here tonight by the full board.
Okay, thank you, Bill. Any questions, comments on this audit? Hearing none, those in support signify by saying aye. Aye. Those opposed? Those abstaining? Motion carries. Thank you, sir.
Thank you very much.
So that concludes all tonight's resolutions. That moves us into new business. The first item under new business is committee appointments. Any objections to hearing them both together? Okay, so hearing no objections, I'd like to entertain a motion to accept the Unit 2 vacancy, which was created with Kathleen Eggert walking on, unfortunately. So we would accept that vacancy, and we would also, let's see here, accept the resignation of Carla Miller from the Unit 4 Elder Subcommittee, and we would change Kenneth Tufnell, and we would move him from an alternate to a regular member in that committee as well.
Motion.
Is there a motion?
Motion.
Motion by Isaac, supported by Lana. Any discussion? Hearing none, those in support signify by saying aye.
Aye.
Those opposed? Those abstaining? Motion carries. Thank you. Next up is Conservation Committee appointment. So we workshopped this earlier today. There's 5 individuals that are trying to get on the Conservation Committee. We can only accept 4. With that, I would like to entertain a motion to appoint the 4 individuals that were supported by the board during today's workshop.
Motion.
Motion by Larry, supported by Bridget. Any discussion?
Yeah, I have an objection. I tried to get my hand up there. I would like to handle them separately, the non-fisherman appointments and then the fisherman appointments separately.
Okay, so would anyone else like to do that? Okay, majority rules then. Those in support signify by saying aye.
Aye.
Those, those opposed?
I'm opposed.
I'm opposed.
Okay, we got 2 no votes. Any abstentions? Okay, no abstentions, motion carries. Thank you very much. That brings us to commercial fishing license. This was an item that the Board of Directors waived the rules to add tonight. With that, I'd like to entertain a motion to revoke the commercial fishing license from the commercial fisherman referenced in today's closed session, which is license C66, due to ongoing reports of aggressive behavior and environmental issues caused by this individual. Is there a motion?
Motion.
Motion by Larry. Support by Sean. Any discussion? Then without objection, we will approve this via unanimous consent. Is there any objection? Hearing no objection, this item passes via unanimous consent. Does anyone have any board concerns at this time?
I have one.
Go ahead, Rob.
I would just like to ask legal to give our members a quick update on where we are
All right, can you hear me? So we just got back late last week, the first step of the informal review from the local Bureau of Indian Affairs office. I'm doing a memo that I'll submit to the board on what their comments were and any responses that the legal department has. The board's next step is they need to set this for a workshop to discuss if they want to modify, tweak, or discuss anything that the BIA may have flagged. I will let the board know, and I already did, and the members here and anyone on Zoom, the BIA didn't flag any major concerns, nothing violating federal law or tribal law, nothing inconsistent with the draft amendments. They just had a couple of clarifying questions, so it should be easy to sort through the BIA informal review. Once the board responds to that, there's a second level of informal review from the regional office in Bemidji with the BIA. If they have any comments, questions, concerns, et cetera, then the board will workshop those. And then after that's completed, it can be on whatever the next agenda after that for a vote if the board desires.
All right. Thank you, Ryan. Appreciate it.
Thank you, Ryan. Austin, can we get that scheduled soon, please?
Yep. Let's get it on there. Yep. Okay. So I have Aaron, then Kim Hampton.
Who has control of my mic? I do. Just don't shock me. I'll just say it really loudly. Does anybody watch CHOP on the Food Network? Tonight, indigenous people are competing, and I think they're going to make indigenous food, so let's see if there's any fry bread. It's at 9 o'clock on the Food Channel. Chopped.
All right. Thank you, Aaron. Kim Hampton.
Muskrat, that's what I would cook.
So I already had this written out before we had gotten an email at 5:08 about the Escanaba Traditional Medicine Room. My concern at the time, which prior to this meeting now, was that Larry, Barb, you and I have been in contact with those we needed to be in contact with since 3/28 with no resolve. I will quickly read this email just so those who had those questions are aware of the resolve. So after conversations with all of the parties that needed to be involved, the Traditional Medicine Office will be available for elders on days that there is an event.
Oh, good.
Below are examples of events that have occurred and 2 more that will be occurring that they would have been approved for. On the days, the facilities administrator will allow access to the Traditional Medicine Office. The room is equipped with upper and lower lockable cabinets and drawers. This is where the sacred items will be stored, and only the traditional medicine team will have access to those. Moontime teachings are to be honored, and any women on their tribe will not be permitted into this room. If approvals are intended to support elder-specific use, Elder Services, Katie, Peabody should present any requests from elders directly to health for approval, allowing a week's determination time. Requests previously that would have been approved would have been like winter ceremony, women's water ceremony, drum workshops. So the 2 events that are scheduled for future that it will be allowed for is 5/9/2026 Women's Gathering and 9/26/26 for Fall Ceremony. So there is a resolve. Obviously, miscommunication, a little error in procedures, but it is resolved. Obviously, there's a process, and we will make sure that the Escanaba Community Center is aware of the exact process that has to go through to get that approval. So,
Okay, thank you. Anyone else? Okay, so that concludes all the items that we have on today's meeting agenda. So without objection, meeting adjourned. Hearing no objection, meeting adjourned. See everyone next Tuesday.